believe you're entitled to 10 minutes of oral argument. If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Craft, the legal persona.
Today's Sovereign Citizen Hall of Fame nominee is Kevin Dwayne Craft, a man who treated accountability like a suggestion and logic like a bargaining chip. In this video, we're breaking down how he didn't just argue with a local judge or file the usual pile of pseudo-legal nonsense, but boldly carried his case all the way to the Michigan Court of Appeals, not to defend some fictional right to travel, but to claim the state had no authority to make him support his own children. It's a perfect example of deadbeat behavior dressed up as legal theory, and a reminder that confidence without comprehension doesn't lead to justice. It leads to a spectacular legal meltdown, so let's dive in.
I'm not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for that summary judgment, please.
You've asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future, we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on me?
Hold on. You're the one who personally hauled this case all the way to the Michigan Court of Appeals, and now you want to stand there questioning whether they even have jurisdiction over you. That argument collapsed the instant you filed the appeal. As for what you keep calling context, the court's authority over you isn't some hidden loophole or legal magic trick. It's firmly rooted in personal jurisdiction and statutory law, clearly established under the United States Constitution and reinforced by the Michigan Constitution. This court didn't wander into your life uninvited. You asked it to review your case, and by doing so, you placed yourself squarely under the very system you're now trying to pretend doesn't apply to you.
We're acting under the state Constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kennar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people just representing themselves. And that's what took place in this matter.
But is it really, though? Because Haynes v. Kerner made one thing very clear. Claims of civil rights violations can't just be waved away without giving the claimant at least some opportunity to present supporting evidence. And let's be honest, your case isn't that. You didn't present evidence of a constitutional violation. You presented a mountain of frivolous motions, all of which were promptly and correctly denied. Somewhere along the way, lost in that delusional fog of sovereign logic and self-inflicted legal mythology, you convinced yourself that a judge telling you no is the same as suffering an actual constitutional injury. It isn't, not even close.
And guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities' liability under the section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I denied any consent or any contract with the state or Title 40 agency to give away my biological and genetic material.
Oh, now it makes sense. This was never about rights, jurisdiction, or the Constitution. This was about not wanting to take care of your kids or pay child support. So instead of stepping up, you went full sovereign citizen, convincing yourself the law doesn't apply to you, wrapping that refusal in bargain bin legal theory, and marching into court thinking you discovered the ultimate loophole. What you actually did was take a basic parental responsibility and turn it into a very public legal embarrassment, complete with a written appellate opinion explaining exactly why none of your nonsense worked.
That the case Monell is relevant because it underscores the importance to ensure that government agencies like the friend of the court on this context, these are for-profit agencies disguised as government agencies like the friend of the court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, was this a constitutional court? The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirements.
Well, there's your first problem right there. Michigan Compiled Laws Act 205, better known as the Parenting Act, already spells this out in plain, unambiguous language. It gives the state clear legal authority to order DNA testing in cases exactly like this. It explains how that DNA may be obtained, lays out the procedures the court must follow, and even lists the consequences for refusing to cooperate. This isn't some secret power grab or a surprise government ambush. It's codified law that's been on the books for years. Whether you like it or not, the statute answers every single question you're pretending is still up for debate.
The state of Michigan stated that it would pay the cost of the genetic test. And if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarm.
Let me guess, that's when the internal oh no alarm started screaming. The moment it sank in that this was about to cost you real money, and that despite all the paper terrorism and discount lawyer magic tricks, the court was still going to do what courts do, confirm what everyone already knew. You are the father, and no amount of sovereign wordplay, invented doctrines, or legal cosplay was ever going to override biology, statutory law, or your obligation to support your own children.
The state of Michigan is also a business. And with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice to Notice of court to refusing to appear voluntary, and I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for just quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure.
Asked and answered. Michigan Compiled Laws Act 205 provides complete transparency on this issue. It clearly establishes the state's legal authority, lays out the procedures for administering paternity testing, and spells out the consequences for refusing to comply. There's nothing vague, nothing hidden, and nothing unconstitutional about it. The statute resolves every question you keep pretending is still open, and it undercuts this entire argument before it even has a chance to leave the ground.
In Burns 322 BR 719, a creditor must provide proper documentation such as a promissory note, contract to substantiate a debt or court claim. They did not. More documents I filed. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. You know, I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Friend of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a corporation.
Yeah, no, you're not a corporation. And honestly, at this point, I'm ready to hand this guy the stupid, dumb information I didn't need to know today award, because the things he keeps insisting on arguing are just wild, pointless, and completely detached from reality. We've gone from bargain bin pseudo-legal theories to outright denial of basic responsibility, and somehow he's still acting like he's dropping knowledge bombs. In reality, all he's doing is racking up shame points while the court and everyone else watches in disbelief.
I'm a living, breathing person, human being. With these being businesses, they have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458 of the Social Security Act, incentive payments to state. It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them it incentivizes them to collect more child support.
What do you think actually happens when you pay child support to the state? It doesn't disappear into some shadowy debt collector vault or get traded like bad credit on Wall Street. The money goes to the child's guardian. The state's role is that of a neutral intermediary, not a payday buyer, not a profiteer. Its job is to make sure the support you legally owe actually reaches your kids. So all that whining about the state taking my money is pure nonsense. The system isn't out to screw you. It's there to enforce your most basic responsibility as a parent.
The main argument I have here and for you guys is full disclosure. You know, it seems like they enter me in a contract without my consent, without full disclosure, and that's the problem here. You know, I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22, and it's basically evidence they didn't provide any evidence of an injury or injured party. And,
Mr. Kraft, you're out of
Yes.
time. We understand that you raise issues of disclosure,
yes,
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know, we have your brief.
Mhm.
We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case. And then you'll get an opinion from us sometime within the next few weeks.
If I may, one last thing.
You've got, if you can do it in 20
I
seconds.
can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I will ask you to dismiss this without prejudice.
All right, I'm gonna assume the long answer and the short answer are exactly the same. Nope. And with that, that's it for today's video. The judge says a decision will be issued in a couple of weeks, and you already know the moment it goes public. I'll be there breaking down the sovereign citizen's inevitable and spectacular loss. If you enjoyed the video, hit that like button. If you didn't, hit dislike. Fair is fair. But either way, drop a comment below, subscribe, and turn on notifications so you never miss what's coming next.